What is the burden of proof? The burden of proof where and in what court? My intention is to tell you what the burden of proof is in a guardianship, an adult guardianship proceeding. But you know what? I'm going to take us on a tour of the burdens of proof. Burden of proof, cut to the chase. The burden of proof in an Article 81 adult guardianship case is clear and convincing evidence. Clear and convincing. It's a civil proceeding. It takes place before a judge. It's called a bench trial. And clear and convincing means there's substantial evidence that I reasonably believe that this is true. And the burden is on the petitioner to demonstrate that the alleged incapacitated person has a functional limitation in their ability. They could be a harm to themselves or to others. That's it. It takes place in the Supreme Court. Every county has one. Every county has this is New York, and every county has a guardianship part in the Supreme. In the news, there are some famous personalities and celebrities that get tried in criminal court. The burden of proof in criminal court is a higher stance called beyond a reasonable doubt. Beyond a reasonable doubt, I believe this to be factually accurate. I believe the sun will rise tomorrow. I think that's as good as it's going to get, right? Factually speaking, I believe that. I don't know why I use that example, but it's really significant. It's the highest burden. I could doubt a little bit, like a reasonable person, not like doubting Thomas, not let me touch the rib, but really, I believe in civil court proceedings, suing someone for money, suing for custody, suing for equitable distribution, a divorce. That burden is by a fair preponderance of the evidence. Fair preponderance. What does that mean? I like to think of it on a scale. And if you had the scales of justice, you see them on all of the statues, any representation, logo of the legal community as a scale. And how do we weigh justice? Well, a fair preponderance of the evidence is 51%, just 51% that this side is a little bit better, has advanced a more persuasive argument, only just slightly. Little tilt, or even, this is even tilt, 51%. Now, for the criminal court, beyond a reasonable doubt, they don't give a percentage. Clear and convincing, they don't give a percentage. It's not in a rule book. It's not in a law book. It's not anything. I just like to visually represent for myself, for my benefit. So clear and convincing, more than 51%, because 51% is preponderance of the evidence, maybe 68%, 75%, some number, and beyond a reasonable doubt is higher. Not 100%. Nope, I don't have to be without doubt. I have a reasonable doubt. Criminal court, you can have a bench trial. That's a judge trial. You can have a jury of your peers. Some cases 6, some cases 12 jurors. Family court, every hearing or trial, bench trial only, judge only. No juries in family court. That's for custody, visitation, child neglect, support proceedings. No juries at all. Guardianship, adult guardianship takes place in Supreme Court. A judge trial, a bench trial, no juries. Divorce, mostly judge trial. Nearly exclusively judge trials. 99.9% judge trials. You are permitted to ask for a jury the issue of grounds. Grounds may have receded into the background because New York used to be exclusively a fault state, and 2 years ago they did introduce a no-fault divorce, irretrievable breakdown of the marriage. So it's hard to have a trial on that, because if I assert that there's been an irretrievable breakdown of the marriage for more than 6 months, you can't really refute that I said there was a breakdown. Me saying there was a breakdown is a breakdown. That's logical. It's a circular argument that we advance in the law. So those are the grounds for divorce. We did a tour of the courts. If you have any questions, if you need a lawyer for your trial, FrankBrunoLaw.com.